On March 9, 2020, YouTuber Wayne Eldridge uploaded a video titled, Eugene, Oregon Police Violating My Rights, which shows a few police officers near Mahaney Drive in Eugene, Oregon investigating an alleged parking violation. When they arrived to the scene, they found various needles in the vehicle, which is typically a sign of drug use in that city, and began to detain and question Mr. Wayne, who was in the driver's seat.
Alright, this is Eugene Police Officer Sunquist.
That's me.
Okay. He says he saw something in the vehicle, so I think the girl in the back seat was diabetic, but this isn't my car, so I have no idea.
Keep your hand out of your pocket, sir. Thank you.
Hello.
Howdy.
What's your name, bud?
I'm not gonna give you my name.
Okay, fair enough. So Wayne, here's the deal.
I wasn't doing anything wrong.
Here's the deal. You keep putting your hands in your pockets, I'm gonna pat you down for weapons. All right, man? Fair enough?
All right.
All right.
Can you wait over there, sir? Can you wait over there, sir? Yeah.
Wayne, just relax right there, right? You're not gonna have any guns, knives, nothing like that? Nothing gonna poke me, stick me, stab me, nothing like that?
No.
Can you face the car this way just so I can get the other side? There you go. Thank you. What's that object? Mind if I look at that?
No.
Don't mind?
I'm not giving you any permission to do anything.
Okay. So I said, do you mind if I look at it? You said no.
Yeah, I do
I'll
mind.
take that as you don't mind.
I don't want you going through my pockets or anything. But you are anyways.
No, I'm patting you down for weapons.
Okay.
Because he's asked you repeatedly to keep your hands out of your pockets, right? And you couldn't seem to do that.
No, my hands are out of my pocket.
Well, they are now, right?
Yep, after you asked me.
Okay.
In the 1968 case of Terry v. Ohio, the U.S. Supreme Court said that law enforcement officers may briefly detain an individual if they have reasonable suspicion that the person stopped is involved in illegal conduct, and once stopped they may conduct a pat-down of the person's outer clothing if they have reasonable suspicion that he is carrying a dangerous weapon, like a firearm or knife. Reasonable suspicion is an objective test which asks what an average individual in the officer's position would reasonably believe. For example, in the case of Illinois v. Wardlow, officers were found to have had reasonable suspicion when a man in a high-crime area portrayed nervous and evasive behavior upon seeing the police. But in Brown v. Texas, reasonable suspicion was found not to exist simply because a person was in an alley known for illegal drug exchanges. In the 2009 case of Arizona v. Johnson, the Supreme Court said, to justify a pat-down of the driver or a passenger during a traffic stop, the police must harbor reasonable suspicion that the person subjected to the frisk is armed and dangerous. Additionally, Oregon Revised Statute 131.625 says, a peace officer may frisk a stopped person for dangerous or deadly weapons if the officer reasonably suspects that the person is armed and dangerous to the officer or other persons present. It appears the only evidence to suggest that Mr. Wayne was armed was the fact that he continued to keep his hands in his pockets. Even if this was a willful act on Mr. Wayne's part, his passive resistance to the officer's orders, without more, very well may not justify a frisk for weapons.
Well, do you want to go wait over here then? If you want to
Sure.
be in the middle of all this?
Do we have a Station 2 yet?
No, not that I've heard.
I was gonna
Where am I? Where do you want me to wait?
Yeah.
Where am I waiting?
Hold on a second, right?
Okay, he's tripping me out. He's filming you guys. I'm just getting kind of awkward. I don't know.
Well, if he's tripping you out, why would you want to do it, right?
Well, yeah, you're right. I don't know. I'm just trying to make sure.
Sir, could you take a seat on the ground, please?
You want me to sit on the ground? I can't sit on the ground.
Why not?
Because my knee is up. I got a cancer. I'm going through treatments, and I broke my knee about a year ago. And I've had surgery, so if you can get me a stool or something to sit on, then sure.
Where do you think I would get that?
Well, you expect me to sit on the wet ground, and then I got a bad knee, so.
So, we're going to need to get your name, sir. You are doing a parking violation by parking in front of a
I didn't
parking
park here.
sign.
I'm not going to give you
You're
my.
sitting in the driver's seat. Do you have his name?
I have the possible Wayne, that's all I have. Him?
Yes.
Yeah, I just have a possible
So he was in the driver's seat. So he's sitting on the needle cap, and he's responsible for the no parking signs for a parking violation.
Copy that. That might be his wallet down in there then, too.
to identify himself.
So Wayne, you catch all that?
I'm not answering any questions. I'm not giving you my name. This isn't Nazi Germany or Russia. You can't just pull people over and pull them out of their cars and start demanding their IDs. This isn't Russia. This is America. I have rights.
Oh, we didn't.
I know my rights.
We didn't win it yet, right? To add to the suspicion, when the cop
This-
car came, they both popped out of the car.
This isn't my car, and
Copy that.
this isn't my car. I wasn't
Even though
driving.
they said they were here waiting for someone, which I don't think you'd leave if you were in fact waiting.
I didn't say anything.
Just giving you full info.
Yeah, no, I appreciate that.
Missed a little bit.
So since you're in the middle of this, you want to sit down for a minute?
I can't sit down
Why not?
because my knee, my legs all messed up.
Okay, can you sit on the hood of the car then?
Yeah.
Okay. Would that be your wallet that's...
Nope. Nothing in this car is mine. This isn't my car.
Whatever, 6-7. Well, you see the issue we got going on, right? Can you at least be reasonable enough to have a conversation about it?
I'm not having any conversations. I wasn't doing anything wrong. I'm not breaking any laws.
No.
I don't have to cooperate.
So for the purpose
I don't
of
have
the
to
citation,
cooperate.
since you were in the vehicle that's parked in a no parking zone,
I wasn't doing anything. I wasn't driving. I wasn't breaking any laws. I don't talk to police. I just don't. All right? I know my rights. You might not know your rights, but I know my rights.
okay, and what are your rights?
Am I being detained right now? I'm not committing any crimes.
According to the U.S. Supreme Court, an objectively reasonable belief is required to detain a person, regardless of the offense. Oregon's rules are slightly more complicated. Under the Oregon Constitution, for police to stop a person for a criminal act, they must have reasonable suspicion. According to State v. Maciel-Figueroa, reasonable suspicion under the Oregon Constitution requires specific and articulable facts that give rise to a reasonable inference that the defendant committed or was about to commit a specific crime or type of crime. On the other hand, according to the 2015 Oregon Court of Appeals case of State v. Gordon, under Article 1 Section 9 of the Oregon Constitution, a traffic stop is lawful only if the officer who stops the vehicle has probable cause to believe that a traffic violation has occurred. The Oregon Court of Appeals in State v. Balabon explained that probable cause means the officer must believe the person committed the violation, and it is objectively reasonable that more likely than not his belief is true. The officers in the video suspect Mr. Wayne of illegally possessing drugs, which a court could find to be true under the circumstances. Additionally, while there is no case law explicitly stating that being in the driver's seat of an illegally parked vehicle does or does not constitute probable cause that the person illegally parked the vehicle, since probable cause is simply a more likely than not standard, it is very possible that probable cause would be found in this case.
So I don't have to give you my name.
We're talking about a violation for purposes of citation, you certainly do.
Well, I don't see.
Suspicion of possession of narcotics.
I don't see. I wasn't violating any laws. I wasn't committing any crimes. I don't have any drugs. I haven't been doing any drugs or hypodermic needles or any of that.
Okay.
Wayne, this is, we're not just going to walk away. I'm not going to be beating around the bush about that. We're going to identify who you are, and we have to figure out if there's any drug involvement here with what we see in the vehicle.
Well, you're not getting anything from me.
Well, you might end up going to jail.
I don't care.
You are required to identify yourself. You've committed a violation.
Now, if you guys arrest me, I have to give you my name. But if I'm not under arrest, then I don't have to give you my name.
Okay, if you need to be obliged with being arrested, then that's something we can accommodate.
So you're going to arrest me. So you can...
If you refuse to identify yourself...
I don't have to identify myself. That's not the law. That's not a lawful order.
So I want you to ask yourself, who do you think maybe knows a little bit more about the law? You or I?
You don't... You can't just... I'm not...
Let me ask you a couple of factual
I'm not
questions.
committing any crimes. I know my rights.
Is this
I don't have to
parked?
talk to you.
Wayne, let's break this to the simplest...
I'm not going to
form
answer
we can.
any of your questions.
Is the vehicle parked? The answer is yes. Were you in the vehicle? The answer is yes, therefore you're parked. You're in front of a no parking zone. That is a violation. You can get a ticket for that. In fact, it sounds like you're going to get a ticket for that. For that purposes, you have to identify yourself. If you don't, we'll take you down to the jail to fingerprint you and wait there until you get identified so we can put the right name on the citation.
According to Oregon Revised Statute 811.411, it is a Class D traffic violation to stop, park, or leave a vehicle in an area prohibited by law, regardless of whether the person stopping, parking, or leaving it was the owner or someone else. In Hiibel v. 6th Judicial District Court of Nevada, the Supreme Court ruled that people who are lawfully stopped under the Fourth Amendment may be required to identify themselves. These so-called stop and identify laws permit the police to require a person to give his name, address, date of birth, or other identifying information during a lawful stop. Oregon law generally places no requirement on an individual to identify himself when he is suspected of a criminal offense. However, under Oregon Revised Statute 810.410, Section 3B, a police officer may stop and detain a person for a traffic violation for the purposes of investigation reasonably related to the traffic violation, identification, and issuance of citation. While the statute does not explicitly say a person must identify himself, it makes clear that a person may be stopped until he provides it and is issued a citation. It's also safe to mention that Oregon Revised Statute 807.570 does require a person to provide his ID, upon being lawfully stopped or detained when driving a vehicle.
Do you have any questions about that?
Put his name on the citation, because his car, it's not mine.
Sitting in the driver's seat. You're in control of the vehicle.
I'm not in control of the vehicle. I wasn't driving. The keys weren't in the ignition. I just sat down. That's all I did. I just sat down. That's all I did. I didn't commit any crimes. All I did was sit down.
What's that? No, I won't. Nothing like that.
In the 1986 case of State v. Brown, the Oregon Supreme Court established the so-called automobile exception to the Oregon Constitution's warrant requirement. This permits law enforcement officers to search a vehicle, provided that the automobile is mobile at the time it is stopped by police or other governmental authority, and that probable cause exists for the search of the vehicle. This doctrine followed the U.S. Supreme Court's reasoning in Carroll v. United States, which established the same rule under the Fourth Amendment. Consequently, the officer's decision to search the vehicle would only need to be based upon probable cause to believe evidence or contraband is in the vehicle. Since the evidence was the needles which were visible to the officers from the outside, the officers would be justified in entering the vehicle and removing the evidence. It should be noted that this incident took place in 2020, and the Oregon Supreme Court abolished its automobile exception in the 2021 case of State v. McCarthy, which now requires a warrant to search a vehicle under the Oregon Constitution. Ultimately, the officers get an A-. They remained calm, did not attempt to escalate the situation, and did not clearly attempt to violate the man's rights. The detainment was almost certainly lawful, and while the frisk may have been unlawful, hypodermic needles are dangerous, and a court could conclude that the necessary suspicion to frisk was met just as easily as they could say it wasn't. Additionally, they did have the right to obtain his identification if they had the necessary probable cause to suspect him of the traffic violation. They also likely had the probable cause necessary to search the vehicle. Mr. Wayne gets a B. While he generally remained calm and invoked his rights, he displayed a clear misunderstanding of stop and identify laws, which played a significant role in this encounter. It is understandable when members of the public get agitated after being stopped, but this encounter may have ended much sooner if Mr. Wayne had a clear understanding of all the laws at issue.